Now we're ready to move to a new segment. We're going to talk a little bit about how that new Secure Act that was passed at the end of last year works. On this presentation, I'll be working with Brenda Schleiss, and she will be taking the first couple of slides.
Sorry, I was muted there. So as Mark said, the Secure Act has to do with IRAs and how we take money out of IRAs.
Speak up.
Now that it's gone, we realize that the prior law for inheriting IRAs was really pretty good. We used it in estate planning to pass money from one generation to the next generation. So if husband had an IRA and he left his wife as the beneficiary, she could roll over his IRA and make it her own IRA. Then she did not have to take required minimum distributions or RMDs until she reached the age of 70 and a half. So she could sit at that IRA over her own lifetime, deferring the income tax that was due for as long as possible. If husband left his IRA as a beneficiary to anybody other than his spouse, say to his kids or to trust for his kids, the kids would have to start taking RMDs the year following the year of death. And it didn't matter how old they were, but they could, however, use their own age expectancy, their own life expectancy. They could use their birth dates to calculate their RMDs for the remainder of their lives. So this left us with an opportunity to pass money from generation to generation, allowing a lot of growth in IRA assets, as well as a lot of tax deferral. Next slide, please. Joe, next slide, please. Thanks. So the government got tired of that game, and they passed a new law in December of 2019 called the Secure Act. The cumbersome name is Setting Every Community Up for Retirement Enhancement, or SECURE. The law passed the House of Representatives in May of 2019, and then in December of 2019, the Senate scraped it by. It started being used on January 1st of 2020, so only 11 days after it passed. The government really wants their tax money now. They don't want to have to wait from future generations. For the 2020 year, though, the IRS has said that people do not have to take RMDs from IRAs, SEP IRAs, simple IRAs, 401k plans, 403b plans, 457b plans, because of the financial struggles that people are facing due to COVID. This rule came under the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. Joe, next slide, please. Thanks. So a summary of the current Secure Act includes the following changes. At the age at which you have to start taking your RMDs changed from 70 and a half to age 72. You can continue to make contributions to your IRA as long as you like, so long as you're employed. There's no cutoff anymore. You can continue to make contributions even if you're taking RMDs. You can now take $10,000 out of 529 plans. Those are plans set up to save for higher education. You can take $10,000 out of those plans to pay off student debt. After having a baby, parents can now each take $5,000 from IRAs without any penalty. So if my husband and I had another child, he could take $5,000 from his IRA, and I could take $5,000 from my IRA without penalty, even though we were taking it before we reached the age of 72. Now, the most important change from our viewpoint is that they eliminated the lifetime stretch out with some exceptions. And Mark is going to talk about those exceptions.
You ready? So in continuing now what's in the Secure Act and what's going on, as Brenda said, the most important change that we see is that now instead of being able to pull money out of an IRA slowly, that's what the stretch out is, over the life expectancy, year by year of the beneficiary. Now it all has to come out within 10 years of the date of the plan participant. There are, though, very important exceptions. I think we need to see the next slide. There it is. And those exceptions are there in red. The terminology is an eligible designated beneficiary. It used to be that there was a term called a designated beneficiary, and that is still in effect. We still have to make sure that any money coming from an IRA into a trust pays to an individual who we can identify. However, there are certain classes where we, instead of having to pull things out over the 10-year rule, uh, we can pull it out still over life expectancy. One of those exceptions is the surviving spouse. Uh, but ordinarily, the surviving spouse is going to do a rollover of the IRA and be able to continue to use life expectancy that way. But the other three exceptions are ones that we need to pay attention to. That is minor children. We're not sure how that's going to be defined. In our state, you are a minor until you're age 18, but the federal government may say it's going to be age 21. But at any rate, while you're in your younger ages, your child can pull that money out over life expectancy until they hit the age of majority, and then the 10-year rule kicks in. Another exception is for disabled or chronically ill individuals. Typically, these are people that have already gotten a finding of disability from the Social Security Administration. And for those of you who are out in the audience who have special needs children, that's what we're talking about. So we can still use the life expectancy of a special needs child. And then the last exception is for a beneficiary no more than 10 years younger than the plan participant. Let me translate that into plain English for you. That's typically going to apply to a situation where you don't have children, or you're not going to leave everything to your children. You may want to include a brother or sister of yours. Those people are typically going to be less than 10 years younger than you. And so we can use their life expectancy. Now, our concern about applying these rules is when this money gets pulled out and comes into a trust, like a trust for your beneficiary, we may lose the asset protection because the income tax pain is so great that we'll want to pass the money out of the trust so that it can be reported as income on a personal tax return at a lower rate. So that's something that we have to figure out depending on the size of the IRA and the importance of asset protection. And then last is that we're concerned that because of this 10-year rule applying in so many situations, that we can't take advantage of leaving money to a younger generation. But in a second, I'm going to tell you that there's a workaround. It's not perfect, but it's helpful. So let's go to the next slide. So we might need to update your plan or your beneficiary designations and consider the idea of having a separate standalone IRA trust, but we would typically do that for, again, larger accounts. The second thing that you might consider doing is knowing that Roth IRAs are still a good option because the beneficiary does not have to pay income tax as they pull the money out. Even though they might have to pull it out over that 10-year time period, it's not going to cause any pain in terms of paying income tax. This is something that you want to talk to your financial advisor about. If you've got sizable IRAs, you'll want to consider having some of that money be rolled into a Roth IRA, but the planning would be done ordinarily working together with your accountant and your financial advisor. And now here's our workaround, item 3 on this slide, and that is we can consider leaving IRAs both to our spouse and then to multiple other beneficiaries. So you take a large IRA and you basically cut it into pieces. Your spouse will not usually have any extra income tax burden, and then you can take some of the money, spread it over several beneficiaries so that several people are reporting the income tax that come when that money is pulled out of those accounts. So the adjustments we're going to have to make, and we'll have another slide on this later, are we either need to change your plan because there's some things that may need to go in there to make sure that the eligible designated beneficiary can use life expectancy, or we may need to change the beneficiary form so that we are directly naming the trust that you set up for your beneficiaries.